The genesis of the book really was around the Patient Protection and Affordable Care Act of 2010. In many ways, it was an anti discrimination law for the unhealthy. One of the real challenges, I think, of this project is that in thinking about discrimination based on health status or healthism, a new ism in the lexicon, this one is really tricky.
We're in the studio today with UGA Law's Dean of Faculty Affairs, Professor Elizabeth Weeks. In her current position, she helps to promote the achievements of faculty scholarship at the University of Georgia School of Law, in addition to teaching and publishing her own works, one of which we'll talk about in detail in just a bit. Thank you so much for being with us, Dean Weeks.
Thanks so much for having me.
We also have with us copyright law librarian Stephen Wolfson. Stephen is also helping with a lot of the faculty research requests, and he's got a good knowledge of publishing with his background in copyright. So today we hope to have a good conversation with the two of them and talk about Dean Weeks' recent book, Healthism. Stephen, would you like to start?
Well, before we get into it, is there anything you'd like to tell us about the book just before we get started?
Well, it's an exciting project. The notion is to suggest the possibility of a new protected category for the unhealthy, and examine that phenomenon, that experience across a range of contexts.
Great. So can you tell me a little bit about the genesis of this book? How did you get interested in writing about this? Where does this come from?
The genesis of the book really was around the Patient Protection and Affordable Care Act of 2010, or the ACA, or we still sometimes call it Obamacare. And what that law really enshrined was, in many ways, it was an anti discrimination law for the unhealthy, at least with respect to their access to health insurance. And the way that the ACA did that was by prohibiting bans on pre existing condition exclusions and prohibiting um, premium rates based on individual risk profiles. And that's a fundamental shift in how we think about insurance. More typically, an insurer is interested in insuring against unexpected risk, not against known cost. So the ACA embodies a different vision of health insurance as a way to really facilitate availability of access to insurance and thereby access to health care across the broader population. And my co author, Jessica Roberts at the University of Houston, actually had been writing some law review articles on this topic of healthism. And I really got involved in the project, which ended up being the book project, by pushing back at her a little bit, because one of her earlier articles, especially on the health insurance question, really just assumed that the notion of discriminating against people based on their health status was a bad thing, was necessarily a bad thing. And actually, in a one of the responses that I did was in there's an online journal called Jotwell, and I've published and published a review of one of her articles there, pointing out that from an insurer's perspective, of course, there are lots of good reasons to discriminate based on health status, right? As I just suggested, an insurer is no more interested in covering somebody who has a known certain expensive to treat health condition as a property insurer is interested in covering somebody who's in a floodplain or in the middle of a hurricane. So there are good rational reasons for discrimination based on health status. But our suggestion in the book is that there are instances of health status discrimination that cross the line and become normatively impermissible, for reasons that we describe in the book.
It's very interesting. I want to get back to that about your sort of normative ideas with the book, but I want to ask a little bit about the process of writing this book. I didn't realize that it was from this sort of back and forth between you and Professor Roberts. And so you started by writing response pieces, professional response pieces, and then you became friendly, sort of offline.
Yeah, well, we knew each other from health law circles. Jessica's at the University of Houston, and I actually practiced in Houston, so I've had pretty good ties with that program in Houston for a long time, and they have a very strong health law center. So when Jessica entered the academy, which was a few years after I did, she was, a dynamic new scholar and doing some really exciting work, and she was at a school where I already had connections, and so just through professional contacts we had already been in contact. So it wasn't a cold call as far as my commentary on her paper. We already knew each other at that point.
Sure. Let's talk a little bit about this specific process of writing the book. So, obviously you're in two different locations. How did you manage putting this together?
Well, I guess one thing we did was actually we published first some shorter pieces,
Mhm.
including a piece called "What Is and Isn't Healthism," which was published here at the Georgia Law Review, and that piece really solidified our theoretical background and definitional
Mhm.
work for the concept of healthism. So we got some experience co-writing through on the shorter piece, which then helped us develop some strategies for working together on the larger book project. But with respect to the book, we really, some of the subject matter specific chapters of the book, we divided up where Jessica had primary responsibility for the chapter on the disability discrimination and privacy laws. I had primary responsibility on the health insurance laws, as well as on the private law chapter. So we really divided up those chapters. By our expertise. And then the introduction and the conclusion chapters we mostly co-wrote.
Mhm.
So it came together pretty smoothly.
Well, I want to get back to the content of the book, specific content of the book a little bit. I find it interesting that it came from this sort of back and forth, professional back and forth between you two, because the balance is obvious from the content of the book. I think it's really clear that you're trying to take a measured approach and look at sort of all the sides that you can. But I'm interested if you ever thought about writing sort of more of a popular piece or a piece that was arguing for a point more, that takes more normative stances than you currently do in the book.
We certainly have thought about writing a more popular piece, and even in writing this, although it's with an academic press, it's with Cambridge University Press, we really aimed to write it at a level that was not overly technical and that would be
Mhm.
accessible by lay readers as well. Um, And in terms of the normative stance, I mean, one of the real challenges I think of this project is that in thinking about discrimination based on health status or healthism, a new ism in the lexicon, I mean, this one is really tricky because there are lots of instances, as we acknowledge in the book, where it's actually okay and maybe even a good thing that people are treated differently based on their health status. And I don't think it's easy to say that about most other
Mhm.
protected categories. There are much fewer instances in which we think, well, actually, it might be a good thing to treat somebody differently based on the color of her skin or her gender
Mhm.
or her pregnancy or her history of military service. We recognize that differentiating both favorably and unfavorably based on health status may have some real health promoting effects, may help people access healthcare in a different way than they might otherwise be able to. And so that's, I think, the necessary tension in the book, which the more nuanced approach just has to account for. We just can't write a sweeping, strident piece that says health status discrimination in all context is a bad thing.
That makes a lot of sense. So I'm wondering about how you deal with when we're considering healthism. How do we deal with changing science? Since part of part of trying to understand what is healthist and isn't is trying to make sense of the science and the data.
Yeah.
How do we make sense? Like, how do we make sense of changing science, of changing our changing understanding of health?
Yeah, no, that's a great question. And we do consciously incorporate into our definition some notion of whether the particular law or policy or practice that is treating people differently based on their health status, whether it has an effect in terms of improving that individual's health or health of society at
Hmm.
large, which necessarily requires some empirics, right? To know whether this smoking cessation policy by an employer actually reduces smoking and thereby reduces healthcare costs. That's a science question, and you're right that science is going to evolve and change over the course of time. So again, I think just to be realistic, we have to include that in the definition. And i- one of the analogies we make in the book and that I've talked about in other contexts is it's um, a multi-part approach that requires consideration of a variety of factors, including the scientific question. But that's not necessarily a concept that the law is a stranger to. Um, for example, in torts, which is one of my areas of teaching, we spend months in first year torts on the reasonable care standard for
Hmm.
negligence. What is reasonable care and how do we define that? And there are various approaches. There's a behavior or a law and economics sort of balancing test approach to that. There are normative approaches to that. There are just a variety of different factors that go into it. And what we consider reasonable at one point in time and in one context may be quite different from what we consider reasonable at a different point in time in a different context. And I think our definition is similarly fluid and admittedly, in some ways, then similarly challenging as understanding reasonable care is for first year law students.
Well, I have to say, I found the book very interesting. I think you're right that you wrote it at a very approachable level for even, I'm a little bit more skilled of a reader, but even like less skilled readers in the area. So I found the book very enjoyable and easy to understand and follow.
Great.
Thanks for writing it.
Thank you so much for reading it.
I would also really love the fact that the cover is a little bit more approachable, I feel like, than a lot of legal or even just academic books. Was there a certain idea behind the cover to sort of make it a little bit more approachable of a book?
Absolutely. I mean, we actually, kind of typical practice in academic press publishing is to get a selection of Getty images, and you can pick the one with the doctor in the lab coat or the one with, and we just weren't really very satisfied with any of those. So actually, Jessica, her assistant at the University of Houston, has done some graphic design work, and we commissioned her to do the cover, which we were really, really happy with, and fortunately, Cambridge went with it as well. And of course, the idea, it's pretty clear to identify that particular individuals within the larger group of the population who have these differences and whether differential treatment on that basis is warranted. I guess the one thing that the pictograph does not represent are sort of unseen or less objective health conditions, mental health conditions, and substance abuse. So harder to portray that through a picture, but.
Wonderful. So there are a few other faculty books coming out later this year and that recently came out last year. It seems like there's a great selection. And just like with this book cover, I've noticed that some of the other book covers that are coming out by our faculty are also a little bit, not necessarily more attractive covers, but just a little more eye-catching and a little different. Are there any books that are coming out that you would like to share with us that some of your faculty are working on?
Sure. So another Cambridge University Press title by Beth Birch. She is working on a book, which I think she also had some hands-on work with the cover image, but it's a book that is in her wheelhouse of multi-district litigation, really looking at that practice, that procedural strategy in a much deeper way, building on her prior scholarship, but looking particularly. And it's a really important topic right now, particularly in the context of the multi-district litigation over opioids that's in the Northern District of Ohio. She's also done quite a bit of work on the transvaginal mesh issue, talc, and a host of other MDL and class action topics. So her book is coming out. We also have an exciting book coming out from Professor Lonnie Brown on the history of Ramsey Clark, who was a critical figure in the civil rights movement. He worked as deputy and then later as attorney general in the 1960s. And Professor Brown has deeply examined that history, which is exciting. And then a third book that's coming out from the New Press by Professor Andrea Dennis called Rap on Trial examines the role of rap music lyrics, particularly by self-trained or not necessarily signed artists, on rap lyrics being admitted as evidence in criminal trials for evidence of premeditation and other issues. And she's co-authored that book, and it's a really exciting. New Press is a popular press, so we expect that book to have lots of cross appeal.
Wonderful. I also understand that later this month, actually next Wednesday, you will be having an event surrounding your book. Can you tell us a little bit about this event that's coming up? It seems like you'll have a panel of other people speaking about your book as well.
Exactly. So we're really excited. This is part of an effort across the law school to really celebrate these sorts of seminal career achievements by our faculty. So it just so happens that my book is the first one out as we embark on this initiative. And so I was privileged to be able to assemble a panel of experts in health law to come to campus and talk about the book. So we'll be joined by Professor Stacy Tivino from the University of Las Vegas, Nevada, Jennifer Bennett Schinnel from Vanderbilt University, Ani Satz from Emory University, and Nick Terry from Indiana University, Indianapolis. And that will be, as Rachel said, on the 27th at 3:30. So I'm really excited and really honored by that event.
That's great. Do you already have dates for the other books coming this year for book events surrounding those as well?
We don't yet have dates for those. I believe that all of those books will be coming out actually after the end of the academic year, so we'll probably be looking at next fall for an event that would be inclusive of our entire law school community, which is the goal with these sorts of celebrations.
Great. We're looking forward to all of these events. We also wanted to let anybody listening in know that not only is Healthism available for checkout at the law library, but you can also find nearly every faculty book that has been published, including case books, in our collection. And the forthcoming books are also going to be in our collection. So if you'd like to read them or check them out, feel free to stop by the library. Thank you so much for being with us, both of you.
Thanks so much for having us.
Thank you.
The content and opinions shared by faculty, staff, students, and former students in the On Reserve podcast do not necessarily reflect the views of, nor are they endorsed by, the University of Georgia, UGA School of Law, or the University System of Georgia. They are also not intended as legal advice. Please contact the Law Library at law.uga.edu/library for more information.